I'm Candace CMaze, Executive Director of Foster Care Review. I think it's you. As many of you know, if you read the newsletter, we are going to be having many more cases that are in a reunification posture. We have a goal of reunification because we have initiated an effort with two of the division judges, with Judge Figueroa and Judge San Pedro Iglesias, where they will be referring us cases at the time of the first hearing, at the time of the shelter hearing. And so these cases will be, many of you have had reunification cases. I'm pretty sure you're familiar with those cases, but you're going to be seeing them much earlier in the process than you're used to. And so in talking with staff and trying to figure out what would be the best way to make sure that the panel members are prepared and the panels are prepared to deal with these cases, we decided it was really important for you to have the context of what's going on up in court and to really understand the front end of the system, because typically our cases are what I like to say are on the back end. They're 10 months in, 12 months in, 3 years in, and you know you're dealing with a different kinds of issues than you are when the case is brand new, and you really need to be on top of different issues. And of course, the staff are going to be there to help guide you through. The questions are there in the Form 1, or as I like to call it, the prep report. And so you're not going to be flying without a lot of support, but it's really important that you understand. We're videotaping this today because we are going to start videotaping some of our trainings to make sure they can go online and reach all of our volunteers. We know some people prefer to come in person, are able to come in person, and some people aren't able to make it here at the times that we offer the training. So for certain trainings, we're going to do video. Let's start by going through the context of dependency court, and what do I mean by that? It really takes us back to 7th grade social studies class, at least when I was in 7th grade. I'm sure now they're learning it in like 3rd grade or something, but the separation of powers, the checks and the system of checks and balances, and the 3 branches of government, right? We have what? We remember this way. The judiciary, the executive, and the legislative, right? And these 3 branches are meant to make sure that no one gets too powerful, no one entity gets too powerful to the point where there's not a check on that institution's power. And so how this plays out in child welfare is we have the executive branch, which is the Department of Children and Families, right? They are under the executive branch, and they are there to basically what? Enforce the law, enforce the child welfare laws. Who makes those laws? The legislature. And so these are the laws that govern the behavior of DCF, that govern the behavior of the citizens of the state of Florida. And then we have the judiciary, and the judicial branch is there to interpret the laws, to make sure that the laws are being applied evenly, that the executive isn't abusing its discretion, abusing its power. And so that's really why we have dependency court and how the system interacts. And so as we talk about what laws govern the behavior of DCF and what things are required by statute, keep in the back of your mind that a lot of this is about checks and balances. The other piece of it is also about our rights as citizens of this country. And there's 2 sort of big areas, big rights creators. There's the Constitution, which you all know about, the U.S. Constitution. And then there's rights that are created by the Supreme Court through its decisions. And these are called fundamental rights. So your constitutional rights, the right to life, liberty, the pursuit of happiness. We remember this from the Constitution, I think, again, 7th grade probably. I swear my 3rd grader knows this, so it's a little scary. And then there's the rights that are created through case law, through cases coming up to the Supreme Court. And these are called fundamental rights. So they're not as big of rights, but they're still very, very important. And it just so happens that the right to parent is one of these fundamental rights. So our right as citizens of this country to be a parent is actually part of Supreme Court decision making, Santosky versus Graham. Don't ask me anything else about it because law school was a long time ago. And so it's a serious thing when you think about going into someone's home and basically taking their child from them. It may not be a permanent taking, it might be a temporary taking, like a dependency, or it might be a permanent taking of their right to be a parent, which is what a TPR, a termination of parental rights is, right? It's permanently depriving you of your right to be a parent. And so these are major infringements on citizen rights, and this is why the dependency system also exists, why dependency court is so necessary, and why the laws are drafted in the way that they are to ensure that those rights are not taken away lightly and without due process, without a process in place to make sure that if you are going to temporarily or permanently take away someone's right to parent, it wasn't done just on a whim. You know, my favorite Spider-Man quote, with great power comes great responsibility. And I think it all kind of boils down to that. You know, the state has incredible power, but it also has an incredible responsibility. And that's where the concept of reasonable efforts comes in. That's why reasonable efforts written into the law, because they have the power to go in, remove a child, even before a court gets involved. And they also have a responsibility to take certain steps to protect the due process rights or the rights of the people that they're removing children from. So that's sort of the underpinning. And I think it really helps to think of the child welfare system and the dependency court that way. In 1997, which feels like yesterday, almost quite a while ago now, the Adoption and Safe Families Act was passed, and this is federal legislation. It was seminal legislation. It created a real shift in the way that states were thinking about and treating children and families who are part of the child welfare system. In order to get the federal dollars that each child welfare system uses to provide foster care and other services, each state had to change its laws to conform with the Adoption and Safe Families Act. So it really had a great effect on state law. And it's state law, not federal law, that ultimately governs the child welfare system. So basically, one of the key underpinnings of ASFA, as we call it, is that safety is of paramount concern. It has to be part of family assessment, case planning, and reunification efforts. It's also stated that out-of-home care is supposed to be temporary. Now, this kind of seems obvious to us now, although we know that's not always what happens. But back when ASFA was drafted, kids were in foster care for years and years and years, and their parents were given many, many chances. Maybe some of you who've been with our program a long time remember life before ASFA, where we call foster care drift, right? They were, kids just, okay, well, they parent relapse, we'll give them another chance. Kids in the foster home doing okay. Meanwhile, these kids are basically, not having permanency, not having stability, and the parents are getting many, many opportunities to continue to I won't publicly say that, but to continue to, have opportunities to rehabilitate it. At some point, it wasn't making any sense. So the other big shift was that permanency efforts, and I think we're not quite here yet, but permanency efforts are supposed to start from day one. From the minute that child is taken from their parent, permanency planning is supposed to start happening. So what does that mean? That means if the goal is reunification, efforts need to be driven towards moving that child back with his or her family from the minute that child is removed. First, they have to try to prevent that removal, and if they can't, they have to, and reunification is the goal, they have to be working on that from day one. And so this is going to be a big deal when you start seeing these cases, because one of the questions we're going to need to find out is what prevents this child from going home today? If the goal is reunification, what prevents this child from going home now? What are the barriers, the continued barriers to reunification? And often, people can't really articulate those because once kids come into dependency court, there's this mindset that, well, it's just a process, and now they're part of the process, and they have to go through the process. But really, it's supposed to be a direct assessment at every opportunity that you can, and I feel like we're one of those opportunities to ask, why isn't this child able to go home now? And he may not be, but that question needs to be asked, and that's what we do, right? We ask the hard questions. And ASFA also focused on, that's where a lot of the innovation came from, was started to be seen around the system, the child welfare system, a lot more innovation and a focus on results and accountability, and that's where it all came from. I know many of you know this, but just for fun, just for giggles, we're just going to review who are all these people that make up the child welfare system, the partners, the stakeholders, obviously Department of Children and Families, Our Kids and its full case management agencies, the juvenile court, the guardian ad litem program, Miami-Dade County Public Schools, foster care review, community-based service providers, universities, and there's something I left off here, and seeing you, Lisa, reminds me, also community funders, because that's a big part now of our child welfare system. A lot of even our funds are from private funders. So it's another piece. And universities also, because they're connected with some of these innovations, and important to make sure that what we're trying is actually working. Now, Our Kids, as the full case management agency, actually provides a great deal, as the lead child community-based care organization, does provide a lot of services in-house. And I don't think a lot of people know that, and I certainly didn't until I got to be more familiar with them. And they've been growing and morphing over I think it's about 10 years now that they've been in existence. So they do intake and triage, and I'll explain how that works when I start talking specifically about how a child gets removed and comes into care. They also provide intensive family preservation services. And these are services provided to children and families who a report has been called in, but they're not removed, and it's deemed unnecessary to remove that child because his safety is not at risk, but the family has risk factors placing them in the moderate to high risk level, but the child's safety is able to be maintained and the child's able to be kept in the home. These services, Maribel and I have been learning a lot about them. They are 8 to 10 hours a week in the home, clinical level services, making an effort to maintain that child safely at home, to teach the parents what they need, to provide the supports necessary so that that child doesn't have to be removed. Because we know, once that child's removed, things are difficult for everyone, the child, for the family, and the outcomes are much less positive, quite frankly. Sometimes these intensive family preservation services don't work, and the children will be removed, or the family doesn't engage in the services, and the children are eventually removed. But this is a kind of a triage opportunity, or a diversion opportunity, rather, for these families. You have a question?
So you're saying they spend like 2 hours a day?
I think it depends, but yeah, between 8 and 10 hours a week, depending on what the family needs are. They might go in for a full day, they might go in a couple times a week. I think it depends on the needs of the family.
And what would be examples, or are you coming to that?
I'm not coming to that because I wasn't going to talk about those cases, but basically there's a program called Home Builders. Did I get that right? Remember? Home Builders, and they come in and they basically work with the parents. They help them explore the issues that led them into this system of care. Like, why are they here? What are the things really going on at the core, at a psychological level? They work also on basic needs and basic skills that a lot of our parents don't have. And they work to connect them to supports in the community so that that after I think it's about 9 weeks, the typical case, after about 9 weeks, when the services are hopefully successfully completed, that family knows where to go to get support when there's no food in the cupboard, when they're in crisis, when the child's acting out or has a severe medical issue. A lot of times that's what those families need. I don't know, Maribel, if you want to add anything. So that answer your question?
Yeah, thank you.
Our kids also oversees clinical services, and they have a clinical director. They, as you know, they contract with full case management agencies. At one point, they have family finders, which we've been told now are within the agencies. You know, the agencies are supposed to have their own family. I see some of the faces. So, to the I don't know the extent to which that's actually happening. They used to have a great family finders program that I think was very successful. They oversee, our kids is basically responsible for all those kids who are receiving RTI. So all those post-18 kids who are receiving Road to Independence funds, our kids has its whole independent living staff that oversees those kids. They also have, I think, a great program which is called Nurse Case Management. And the Nurse Case Management program really helps coordinate all of the medical services for the kids. So if the child goes to the doctor, so this is a question you can ask during your reviews. I don't know if you do already, you probably do, but you know, if you see that there's a disconnect, you might suggest to the case manager, you know, have you worked with the nurse case manager unit at our kids to help coordinate some of these follow-up appointments. Some of the things that we know fall through the cracks because the case managers, for whatever reason, aren't able or don't follow up. The nurse case managers are really there to help coordinate assessments and some of the care. Did I overstate what they do? A little bit?
No, well, and I think the important thing is that they really make sure that the kids get the services on the front end as soon as they come in, as soon as they enter care. So that's where you'll see that they've definitely touched the nurse case management unit. From that point on, I don't hear a lot about the nurse case management unit, so it's important that we know that it exists.
Right. So since you're going to be seeing a lot more cases early in the process, you'll probably be hearing more about the nurse case management unit, and also would want to, if you see things breaking down, that would be something we could either recommend or something you could just discuss with the case manager during the review. Our kids also has a really significant quality assurance and sort of data collection and analysis process. I think that because of the way the contracts are designed, and because we know that you have to constantly, they call it continuous quality improvement, I think. Tell me if I get it wrong. And they've become, I think our system, because of privatization, has become a lot more sophisticated in looking at the data and trying to think about what the data tells us. In fact, Maribel and I participate in both a quarterly and also, well, it used to be monthly meetings to discuss data and talk about what the data shows, and our kids has a consultant that they work with who try to come up with hypotheses to figure out, well, why are we seeing this trend and what can be done to reverse this trend, and it's a lot more sophisticated than it used to be. They also have actually an award-winning IT department where they have, which is where all this records, case management records, the ASK system. You've all heard of the ASK system. Don't ask me what ASK stands for. I'm serious. I can't remember right now. But basically, the case manager's documents are all scanned and are all uploaded into this ASK system, so that the supervisors can have access to them, that our kids has access to them. Is there anything else you want to say about ASK? And so they've really helped, I think their IT department has really helped drive some innovation and some more efficient ways of doing things. And we're hoping they're going to help us with that too. You guys know who the case management agencies are. I was just very proud of myself. Next slide. For the logos, because that took a while. Okay, so what happens before dependency court? How does a child end up actually coming into dependency court? Well, it's simple and it's complex. So basically, all investigations are triggered by the call to the abuse hotline, 1-800-96-ABUSE, and it's a state line that I don't know how many of you have called it before. I won't ask for a show of hands, but I have, and it's a varying degree of support and receptiveness on the other end sometimes. And what they're supposed to do is ask you a series of questions about what you observed or what knowledge you have about a particular alleged abuse incident. And they have an assessment process, and they decide, okay, first, where did this happen? Miami-Dade. Okay, they farm the call to the Child Protective Investigations Unit at the Department of Children and Families in Miami-Dade. And then there's a response time protocol, which I don't know off the top of my head, for the DCF, we call Child Protective Investigator, so that's CPI, for the CPI to go out and do the investigation. When you've been reading about these horrible tragedies in the news, this is the group of people that they're referring to. So it's the Child Protective Investigators who've gone out, and what they're supposed to do is a structured assessment that assesses both risk and safety threats. And if the risk is if the risk is low, or they don't even find what was alleged to have happened based on their investigation, the case will be deemed unsubstantiated, and the case is closed. If there's a low risk and a low safety threat, they'll offer them what's called voluntary services. They'll say, it looks like you're having some economic issues. Well, we have these services in the community. They might link them to food stamps, which now has a better, more sophisticated name, or whatever other services are in the community, and then kind of say, you can do it. It's up to you. We're going to walk away. A moderate to high risk, as I was sharing with you earlier, when safety can be protected with the safety plan, or that child can safely be kept in the home, but there's a lot of risk factors putting them in the moderate to high risk category. That's when these families will be offered the intensive family preservation services, the IFPS. And so what happens to get to these intensive family preservation services that we talked about? So the kids are still in the home, they haven't been removed, dependency court hasn't been even talked about, is the CPI, the DCF CPI, is supposed to meet with Our Kids Intake Department. And they have a staffing, and they discuss what the best approach would be. And there's a CLS attorney involved at that point. And there's a meeting basically to determine, okay, here's what the risk is, this is what the assessment says, here's what the safety threats are. Is this a case that's appropriate for these intensive preservation services, or is this a case where the child needs to be removed and brought into the court system? And that's like a real pivotal decision-making process, because that could affect the trajectory of that child for the rest of his or her life. And the Our Kids Intake Department is a very sophisticated, in my opinion. I know a lot of the folks there that actually used to work for me, so I know them pretty well. And they're very high level. I believe most of them have clinical backgrounds as well, so they have another lens that they look at these families through. Now, if it's moderate to high risk, but the child's safety, or the child is in imminent harm, that there's nothing to be done at that moment to protect that child's safety, this is when the child would be removed. So again, it's the Child Protective Investigator meeting with the Our Kids Intake Department, the CLS attorney is involved, and they have that staffing and the decisions made to remove that child. And so those are the kids that we see, but there's a whole other group of kids. I want you to be kind of aware of the fact that there's so many other children and families who touch the child welfare system in some way, whether it's an unsubstantiated report, but there's been an investigation, whether they're offered voluntary services, whether they're offered these intensive services, or whether the child's removed and brought into care. In some cases, a child will be left home, but the risk is deemed so high, and the concerns are so great for that child's safety, not at that moment, but potential issues, that we call it here a straight file, which basically means we're still filing a petition with the court, but we're going to leave that child at home. We want to make sure that that the coercive power of the court is making sure that this family is doing services, is taking advantage. Everything else up to this point is voluntary. Until you get into dependency court, everything is voluntary. But once you're in dependency court, one of the first things that the judge will say is, I now decide what happens to this child. once there's been an adjudication, and we're gonna walk through that process. I now decide what you need to do to get this child back. And I now make the big decisions. And it's a big shift in the power differential, and going back to what we talked about, it's a big impingement on that person's right to be a parent at that point. A lot of the decision making is now put in the hands of the judge, and we'll talk about how that happens. You guys know this, but just in case you don't, there's parties and there's participants. And parties are those folks with due process rights. They're the ones with the most to lose and the most to gain, if you will. That's the state. That's represented by the Department of Children and Families, or our Children's Legal Service lawyers represent the state. Before privatization, the case managers worked for DCF, and they were represented by the CLS attorneys. Now, the case managers are not technically a party to the case, but rather a participant in the case. And in the early years, and possibly even now, that created a little bit of challenge, or a lot of challenge, depending on the relationship, because before privatization, the attorneys represented the case managers. Those were the agency was their clients, but the case managers were authorized agents of DCF. It's a little bit different now. The guardian ad litem is actually a party to the case, a full party to the case, which is why they also will have an attorney, a program attorney. The parents obviously are parties to the case, and as you know, they have attorneys as well. The child is a party to the case, and in Florida, as you know, children who are in dependency court do not have the right to an attorney. In other states, they do. In fact, in Arizona, where I'm from, they do. And that was my original plan before I moved to Miami, was to be a children's attorney in Arizona, representing them directly in court. Now we have sort of an indirect representation model where the guardian ad litem, as you know, advocates for them, and the the guardian ad litem attorney represents that guardian ad litem in the program.
Well, what happens when the child does not have a guardian?
They have no one.
And that seems to be somewhat prevalent.
I know the Guardian program is making efforts to recruit volunteers so that every single child can have a guardian. I think actually they've improved. But yes, it is. It's a problem. And so that's why I think, agencies like ours are so important, because we aren't representing anybody, but trying to make the best recommendations that we can to the judge about what the child needs and what the family needs and the case needs to reach permanency, safety, and stability. But again, I have a strong opinion about this. I think every child at least deserves someone to be in there on their behalf that isn't personally invested in the case. Yes, sir.
Occasionally we see a group called Attorneys for Children, or
Lawyers for Children?
Lawyers for Children, for the University of Miami
Yes.
Law Project. How do they fit into that?
You read my mind. That was scary. A little scary. we're gonna take advantage of that skill. Yes, Lawyers for Children America uses pro bono attorneys, so attorneys who are volunteering their time to act as attorneys ad litem for the children. I actually used to be involved with that program some years ago. It's a great program with great lawyers from major law firms who need support but are really, when they do it well, they do a great job. And then the youth law clinic at the university also has students paired with university law school staff who advocate for kids. I would say they're probably on like maybe 1% of the kids, and it's mostly older kids in my experience. But yeah, you've all had. I know there's been lawyers for children lawyers in your reviews.
Are they parties or participants?
Lawyers, good question. Lawyers, I put them under participants because really they're kind of not even. I mean, they're advocates. They represent parties. So if you're a lawyer, you're in there because you're representing one of the parties. Occasionally a participant might have an attorney. Like I know a lot of the case management agencies now, because of this different relationship, have attorneys or general counsel for the agency who might come in if it's a contentious case or a case where they want to make sure all the right things are said or if there's legal issues in the case. Interestingly, a lot of those folks are former DCF lawyers. Okay, moving on. Okay, I want you to memorize this and we're going to talk about it. All right, this is why, yes, we have a separate handout. Why I have a separate handout because we're going to refer back to this. And this is really, I like to say, an ideal situation of a child coming into the court system and moving through the court system. Did you not get a separate sheet? You have mine. Thank you. I have mine. And so it really maps out the path of a case. And that's what we're going to talk about now for the rest of our time here. Actually, Maribel, I might take you up on that. Oh no, I have another one here. I must have stolen yours. Okay, so what I want to say about this before we really get into it is two things. Number one, ideal is the operative word here. This is really if a case is moving nice and smoothly through the system, like the dependency court system, with no bumps in the road, no issues, no complications. 12 months, we're done, or earlier, ideally. I have yet to really see the ideal, the case move through the system in that smooth of a process. Often there's all sorts of other hearings that happen, report regarding, medical care, report revisitation, you can file a motion here and there if you're one of the attorneys. So there's a lot more hearings that happen. And part of why I like for you to look at it, at this kind of in full view, is for you to understand why sometimes it is difficult for some of the attorneys to be there. Because they're also in court dealing with all of these hearings. We're hoping by the fall the coordination will have improved between our times and their time. And we're really working hard on that. But it is something that's just a reality. And so there's a lot going on in court while you're downstairs doing your work. And moving these cases through the legal process, keeping to the time frames and everything. So we're going to talk about how that would work. Okay, let me just also point out, you don't have to go back, it's okay. On the back side of this, it lays it out in a little bit different way. It gives you the time frames, which some of you I think would be very familiar with, the time frames, and we'll talk about that. But it just sort of is looking at the process in another way. I will say that it's important to remember, and this will be really important for these cases we're getting early in the process, it's important to remember, it is not a requirement that a child be in the dependency court system for 12 months. That's sort of the max. So I think not we, foster care review, but we as a system, and the big we, get into this mindset, okay, well they're in the system and by 12 months we'll figure out what we're going to do. But really, ideally, we want to be every step of the process asking, okay, what needs to happen? And can this child go home if the goal is reunification? If not, is it time to look at changing the goal? Have the parents had enough time to work on their services if we're not at 12 months yet? If the parents have evaporated, you don't have to wait for 12 months for them to resurface. You can say, look, they've now abandoned their children, or maybe they're not complying with their services in any meaningful way, or they're not visiting the children. Those kinds of things need to be addressed early in the process, because the longer they linger, the longer the kid unnecessarily stays in care. The older the child gets, the more difficult it is to move swiftly towards permanency. So, I always like to say 12 months is sort of the major decision-making point, which is that permanency hearing. But a lot of important decisions need to be made earlier in the process. And the thing I love about working with volunteers and that I think our agency stands for is that we're not complacent about just kind of going with the flow, because it's just what happens. You're going through the process. It's about asking those questions early and often. What are we doing here? Are we thinking through all the options? Are we doing what we can to not have this child live his or her life for 12 months or more in the system?
Are these guidelines or required?
Mandated timeframes. Timeframes mandated by Florida statute. Okay. So let's see, I have an hour shelter here. So we've got a call to the hotline, and the investigator goes out, and let's use our scenario we created earlier, where dad's been arrested and is now incarcerated in jail for domestic violence. The mother was severely wounded and is in the hospital, and there's no, the investigator's there on the scene. He was called out by the police when they responded to the call, and he said, he's talking to the neighbors, trying to figure out, is there anywhere I can put this child? And they say, no, we don't know these people, they fight a lot, that's why we called the police, because the mom was screaming, and we don't know really much about them. The child's young, doesn't really have the ability to explain, to the investigator about relatives or whatever. That child is going to a shelter that night. So a shelter could be a foster home. It's a regular foster home that provides shelter care. So there might be a couple other children in the home, or it could be a group setting shelter, which I know of one that we have. I think we've stopped using that model for young kids especially, but I know I just read a report that apparently we, as a state, do that a lot. So that child spends the night in the shelter, and within 24 hours of removing that child, the investigator will have staffed the case with a CLS attorney, will have staffed the case with the intake department at our kids, and will be prepared to file a shelter petition with the court within 24 hours. Some states, the statute says 7 days. Some it's 3 days. We have one of the fastest, which I think is really important myself, is 24 hours, 1 day before the court takes a look at that decision to remove the child, right? And so we have here for you, okay, Vanessa, you're going to help me change to the, I have just an example of a shelter petition. Rather than print and kill trees, we decided to try to do it in a technologically savvy way. Vanessa is
What do you want? The affidavit of petition?
the affidavit, yeah. And so, I'm going to try to look forward. The affidavit and petition for placement in shelter. How many of you have seen one of these documents? No. So we're going to start using them in our training, so you know. But it basically talks about, as you can see, it talks about the child. And I didn't quote the story from this. I just made up my story, but the child, and go ahead and just kind of go down. It talks about why this child is alleged to be abused, abandoned, or neglected. In other words, dependent. Talks about any history with the department. In this case, there's quite a history. 5 other kids. Long history here. Go on down. All the reports in the past. And we receive verified and some indicators. Some indicators mean they've investigated the charge. There were some indicators that it was true, some indicators that it wasn't. The verified means if the report obviously was verified. And then the no indicators is the unsubstantiated. You're like Vanna White. It's awesome. All right, go on, keep going. Vanna, Vanessa, it's all the same. They have to have made reasonable efforts to prevent the child from being removed. So are we going too fast? Okay. There's that, did you see the ICWA question? Keep going up. Member of a tribe. Wait, you went too fast? You guys always ask me, what's this ICWA question on our Indian Child Welfare Act question? Okay, so the court has to find out. This is all done within 24 hours. It's a very chaotic and challenging time.
This is weekends, morning, noon, and night,
24/7,
365. So what happens if they are a member of a tribe? Then do you have
Then
to
there's
determine-
there's just a different process. You have to do different kinds of notice. You have to reach out to the tribe. There's a whole other process that happens. We should do an ICWA training. I am not an expert on it, but it's very interesting. It's a much higher standard that they have. You have, instead of reasonable efforts, the standard is active efforts. The default is not either, if reunification doesn't work, adoption isn't the default, the way it is in our preferences of permanency. It's very interesting. Anyways, not to digress. Okay, so parent information, and then pretty much at the very end, this is a sworn petition, it's an affidavit, so the investigator has to swear that what's written here is true to the best of his or her knowledge, and then signed off by the CLS attorney for legal sufficiency. Okay, so this is the document. This one is printed, but back in the day, they were all handwritten. You might not even be able to tell exactly what was on them, but the judges hear shelter hearings every afternoon at 1:30, so if you guys, 1:32 depending on the judge, if you guys ever have downtime or your case is canceled or whatever, those are really interesting hearings to go and see, because it's very, 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 very low burden of proof. The burden of proof is probable cause. If the judge basically doesn't have to hear any testimony, the judge basically looks at this document and says, assuming that these things are true, does this rise to the level of abuse, abandonment, or neglect as defined by Florida statute? And so we call it, probable cause. You look at the four corners of the petition to make a decision as a judge, whether or not the removal was justified. The judge also has to find that services were offered, or relieve the department of providing services because the situation was so severe. So the court will then, believe it or not, a lot of parents end up at these shelter hearings. Think about that too. So you're in the field, it's crazy, it's chaotic. The investigator has to make sure that this parent has notice of a hearing about this removal. And so they might write it out, or they might call them depending on when the investigator themselves knows about the hearing. It's kind of a crazy thing when you think about it. And somehow it works. And often the parents will come to court and the judge will say, do you have any relatives? If the child's in shelter, do you have any relatives that we can put the child with? Sometimes the relatives will find out and will come to court and say, I can take the child. It's a very kind of chaotic and emotional hearing when everyone's there. I mean, they just lost their child, maybe they don't understand why. Maybe they're from another country where whatever they did to their child was perfectly acceptable in Haiti or wherever, and they were just doing what they thought was best to discipline their child. And here they are now not having the government come in. Imagine if you're from a place like that, having the government come in and take away, your most precious thing in your life. Even, and when I say this every time I train or every time I talk to people, is that you cannot assume, just in some cases, yes, there's psychopaths and crazy people who are just so violent they don't know how to control themselves. But most of the time, there are circumstances that are out of control, people with very poor coping skills, but they do care about and love their children. They just don't know how to take care of them. We always say love is not enough. You have to have the skills to be able to take care of your child, to be able to parent. It's not enough to love your child. That's important, but it doesn't, we tell this a lot to teen moms, you have to have these skills to be able to take care of your child. So that's often what, they're distraught, they don't understand why their child was removed. So let's say in our case, the judge says, yes, there's probable cause to have removed the child, the allegations are sufficient to have warranted the removal. The court will also ask the parents to consent to medical and educational records being provided to the court. Because right now, remember, it's just a low level of infringement. The parents still have rights. They still have a lot of rights. The court will make an important finding about whether or not the department made reasonable efforts to prevent this removal, whether or not they did. And this is very important, they will advise the parents of their right to an attorney. And if they cannot afford an attorney, they will get one appointed by the court. Now, these cases, by the way, are civil cases. They're not criminal cases. But no other civil proceeding does someone have a right to counsel. If you can't afford one, tough nuggies, you represent yourself. Domestic relations case, a divorce, if you can't afford a lawyer, you're on your own, right? But because of that right, that fundamental right to parent, these due process protections kick in, and one of them, which is very important, is that if you can't afford to hire an attorney, you will have one appointed, paid for by the taxpayers of Florida. Because what's at stake is a fundamental right, and that's your right to parent. So what it does, it's kind of the why do these, I get that question a lot, why do parents get attorneys? You know, other civil proceeding, do they? This isn't a criminal proceeding, they're not gonna go to jail. They're not gonna, they're not gonna, you know, lose their life or liberty, but because it's a fundamental right. Okay. Maybe I'm just a nerd, I think that's a very cool part of our due process protection. I'm a little. Other issues are addressed at the shelter hearing. This hearing is a big deal. Sometimes we don't know where the father or mother is. Sometimes we don't know who the father is. Often we know who the mother is. Sometimes maternity is a question. More often than not, paternity is a question. You know, the cases are organized by mother. And you guys know this, right? So you can have one mom, you can have 5 kids in a case, 1 mom and 5 dads. So say we have a case like that, everyone's been removed from the mom. There was one dad involved, he was there, but there's 4 other kids with 4 other dads. The department has to make sure to notice and involve every single other dad. So a lot of times, you know, early in the case, and maybe even by the time they come to us at the 5-month review, there may be some whereabouts unknown of some of these dads. And one of the things we want to make sure is whether or not the what the status of the diligent search is. You guys know about diligent searches, right? Yes. So we know about it in the TPR world often, but it also is important at this stage of the process. So at this stage of the process, we got to make sure that they're looking for dad A, B, C, D, E, F. Because if they don't make diligent efforts to do that, when we get to the TPR and dad C pops up, it creates a lot of problems. I will say that you would think this wouldn't be such an issue, but it still is an issue. And you see it in the TPR stage. So the other issue that comes up at the shelter obviously is placement. You know, is there somewhere with a relative that's safe and appropriate? Child support issues are addressed at that stage. Educational setting, counseling and services for the child. The judge can now order services and counseling for the child. The judge will also that's when all these assessments start getting ordered for the child. If their child's been on medication, that issue comes up, and any other sort of possible issue you can imagine. Visitation is also a very important issue that's brought up at the shelter hearing. You know, even though there's been a probable cause finding and the child's been removed, you know, is it safe for this child to visit? If so, what's that schedule going to look like? So again, the parent still has rights. And the judge can't order the parent around at this point. The judge will enter what's called a shelter order. A shelter order lists out the findings that the judge has made. We don't have a copy of that here. Okay, so let's look at our path of a case paper. So now that shelter hearing has happened within 24 hours of removal, and when you see within means within that time period from the point of removal. Removal is sort of what starts the clock ticking. The dependency petition is filed within 21 days. Now, the law requires that it's filed within 21 days. Our practice in Miami is to file it within 7 days. And we even have a special hearing for that that's not on this. We call it a filing hearing. And it happens within 7 days. Technically, you don't have to have a hearing. You just have to make sure that it's served. The state, typically DCF, files the petition and has to make sure that it's served on the parents. Yes.
So the hearings go on Saturdays and Sundays as well?
There are emergency judges, like judges who sit and do backup. It's not our dependency judges. It can be any judge, and they do backup. Yeah, it's triggered from the time. At least that's how it used to be. Has it changed? No? Okay. Vanessa, you want to come up and so the dependency petition, and it's called a verified petition for dependency, and it's really intended to, this is really the main important charging document. This is where the child protective investigator has had a lot more time, things are not in, hopefully, in crisis anymore, and he or she has had time to investigate what's really going on. And so what you'll see often is a discrepancy between what was alleged in the shelter petition and what's finally put into the dependent petition. The other piece of it is the dependent petition, the allegations in here are what the state has to prove by a preponderance of the evidence happened. And so the burden of proof is higher. We like to call that more likely than not, right? But they have to put on some evidence. They have to put on some testimony. They have to have proof. It's not just talking about removal now, that immediate decision. Now we're talking about keeping this child away from his parents for a significant period of time, potentially. So this is an even more of an infringement on a parent's rights, and so the burden of proof goes higher, and it's preponderance of the evidence. The petition, and we could just sort of slowly scroll through it. You'll see the lawyer writes this one, and again, it gives a lot of the same information that's on the shelter petition. It's also a verified petition. It's a sworn to petition. Gives the history, whether or not that they participated in mediation. What else? And then it lists the allegations. And so those allegations, all or some of those, are the subject really of the case. So in this case, it's a chronic substance abuse history and criminal behavior that had continued to place the children at risk, continued neglect of the children. And so that's the issue in this case. In fact, in this case, it's just the one child because she's already had action taken as to her other children. All right.
If you're wondering why you don't see these documents, it's because the specialist reads these and interprets them for you, which is where your little brief history comes from of why the child came into care. That comes straight from here.
Okay.
So we've already interpreted that.
Perfect. Thank you. That's so important. Yes. So part of us doing this training is for you to understand where does this information come from? How do we get this information? And what stage are we in? What will happen with this? It also identifies the parents, the biological parents, the legal parents, and those who are unknown. Okay? An important document. Let's go to the next slide, please. So the next hearing that happens, if you look at your path, is the arraignment and shelter review. So at that hearing, which is within 28 days of removal, a couple of things happen. The court, first of all, looks at whether or not that child is, like, what's the status of his placement. Is he still in shelter? Keep going a little more. One more. There. Is he still in shelter? Are his needs being met where he is? What efforts have been made to identify relatives? All of those things related to placement. What's happening with his schooling and that kind of thing. But the main purpose of this hearing is for the parent or legal custodian to enter a plea regarding the allegations stated in the dependent petition. And basically, you know, it's not criminal court, so we're not pleading guilty or not guilty, right? Their pleas will be either they admit to the allegations in the dependent petition, so they're admitting, yeah, I have a substance abuse problem and I neglected my kid. We see that happen a lot. They're consenting to the allegations. They're basically saying, I'm not going to say that this happened. I'm not saying it didn't happen, but I'm consenting, I'm agreeing to my child being found dependent, and I'm agreeing to be under the jurisdiction of the court. I'm agreeing for the court to be able to tell me what I have to do to be able to get back my child. So it's like a no contest plea, right? And then there's the denial. denial plea. And the denial plea, basically, no, none of this happened. I don't agree with anything in here. And that ends up going to trial. We'll talk about that in a minute. Now, most of the cases, at least back in my day, although I feel like a lot of cases are going to trial lately, but back in my day, and I think even probably today, most of the cases will be consent pleas. And often what happens is you start with this petition, it's got all these allegations, the parties either go to mediation, a formal mediation where a mediator facilitates the process, or they have a little meeting, the attorneys chat with each other and chat with the clients, and they say, you know what, the DCF attorney CLS attorney looks at this and says, I can't really prove allegation number 4. I don't really have good evidence for that. I'm going to strike that from the petition. Will your client plead to the rest of the petition? And the parent's attorney will come back and say, my client doesn't have issues with parenting. Her issue is substance abuse. We don't need to go into this whole discussion about parenting. And the CLS attorney might say, oh, no, I feel, we feel very strongly about this. Or, you know what, you're right. She knows how to be a parent. She's just got a real drug problem. It's affecting her ability to parent, but the kids otherwise care for. Not necessarily the best examples, but the best I could come up with at 7 o'clock at night. So they work this out. They negotiate, the attorneys, and they talk with their clients, and they work out a plea. Now, why is that so important? Because whatever they agree to, the judge has to, number 1, approve. Sometimes the judge will be like, no, I'm not taking that parenting thing out of here. Either you guys agree to that staying in there and you take the plea, or we're going to trial. That's fine. Bring it on. And or the judge will say, you know what, that's fine. I approve the plea agreement, and they'll take the parent's plea right there. And they ask them a series of questions. Was this done voluntarily? Were you coerced? Did you understand the consequences of your decision? Do you understand? I wish we had coffee for all you guys, because you're all. I need you to be up. I've got another hour. Do you understand the consequences of this decision? By agreeing to these allegations and agreeing to the dependency, you're now giving me control over where your child lives, what services your child receives, what services you have to take care of, and if you don't complete those services, you could be at risk for permanently losing your right to parent. Parent says, yes, I understand, I talked with my attorney, and the plea is taken. The adjudicatory order is drafted based only on the things that parent pled to. Okay, so that's why after there's been an adjudicatory entered, you can look at this, not you, but we look at this, but if there's already been an adjudication, which there should be by the time we see the case, that's really what matters, because those are the facts of the case. These are no longer the facts. The facts are the things that were pled to. And I think sometimes, we do these broad brushstrokes of, throwing the kitchen sink in to address, 1 or 2 specific issues. Now, there's always bigger issues, it's always the tip of the iceberg for the most part that we're seeing. But let's address what's at the core first, so that we can take care of some of these other less intense issues later on down the line. And I'll get to that one if I get to case money, because I'm being rather chatty tonight. So if the parent enters a denial plea, the case goes to trial, evidence is presented, it's like a real trial, rules of evidence apply, and witnesses are put on the stand, and the judge hears all the testimony and then makes a decision whether or not to grant the petition. I can guarantee you, if a parent goes to trial, there's a lot more known about that parent because there's been extensive testimony taken. And the burden of proof is very low for the state. It's not as low as probable cause, because this is a little more of that infringement, but it's preponderance of the evidence. All they have to prove is that what they're alleging is more likely than not to have happened. It's not that hard to prove it, really. I mean, unless you have an investigator or someone who comes in and says, I totally made it up, or the judge doesn't find a witness credible, or whatever, most of the time the state wins these trials. And now there's a whole findings of fact and all sorts of information and evidence that is now in the adjudicatory order. So you'll know if a case went to trial, because your adjudicatory orders would be like 4 pages or 5 pages as opposed to 1 or 2 pages. And so, yes?
Just to see if I understand. So let's say that the parent says, I don't agree to the allegations that have to do with substance abuse, and there were other things. And they go to trial, and the DCF loses on the question of substance abuse, but the others are sustained.
Right.
So
That can happen. That's a good point.
in the case plan, then, if the case plan said, we want you to do substance abuse, this and that, the parents would have the legal right to say, you don't have any authority to tell
Exactly.
me to do that.
You should just come up here, Mike.
Well,
I mean, that's exactly it, and that's why I really hit this point hard, because you can only require services for those things that brought the child into care, and you see often when you look at case plans, and it doesn't mean that these families don't need other services and supports, and they can agree to other services. I mean, while they're in the system, they can agree to it. But there's I believe the legal language is it has to be rationally related to the facts of the case. The case plan has to be rationally related. There has to be a reasonable, if you have a problem with substance abuse, going to residential treatment makes sense, if that's what you need. Does that make sense? We're going to talk a little more about case planning because I know that's why you're here.
Yeah, makes sense.
So now we're about a month into this situation. Child's been living away from, let's say our child, there are no relatives, been living in a shelter now for a month. Maybe seen the parents a couple of times. I always think about like what this must feel like for these children, and which is why, I feel like, and this is again Candace's opinion, but when a child can safely be kept home or returned home, that helps the child ultimately. Even if not every issue is fixed, as long as that child can be safe and cared for, that's something that the child deserves as much as the parents. There's no right to be parented. There's a right to parent, but I always feel like these children, they lose the most out of anyone, even if it's what they needed, even if it was because their safety could only be protected. At the end of the day, they lose those connections. They lose their family, even a really bad family. They still lose that connection, and so we have to really be thoughtful about that. So the adjudicatory hearing is really the trial. I think I talked enough about that. Important in the adjudicatory order, also again, reasonable efforts. And you're going to see reasonable efforts is kind of a theme. Were reasonable efforts made to prevent removal? Have reasonable efforts been made to provide services to the child? There should be an initial case plan even at this early stage. Services should be offered from day one. So that's another thing that we look for is, by the judicial review, if we see a case plan was entered, but services didn't start, until 5-6 months into the case, or 3-4 months into the case, there's a problem. And that's one of the things that delays permanency. Services need to be offered and provided from day one, even though you don't know as a case manager what the outcome of the case is going to be. You have to offer the services. You have to provide them. That's what the law says. Okay, disposition hearing. So this is now looking at your handy dandy sheet. Disposition is 15 days after arraignment, okay, if the parent entered a plea of consent or admission. It's 30 days from the last day of the adjudicatory hearing, or that trial on the dependent petition. So the other downside of going to trial is it prolongs things, and it's just a little bit more of a delay, because it isn't until there's an adjudicatory order entered that the judge can then order the parents to do anything. And so the disposition hearing, you see off to the side the case planning conference facilitated by the department. It's in the law, and it's supposed to happen with the agencies. They're supposed to have this whole conference where they sit down with the parents and they sit down with the lawyers, and everyone talks about what the services what really services would be meaningful. They talk with the parents about the case plan, what it really means. Big important question for us to ask. What was the process under which this case plan was developed? It's my belief that they're not happening as often as they should, or like these education and career planning things, they're sort of just, people kind of filling out forms saying, okay, you're going to do this, this, and this, let's go.
This is about 4 months into the process.
Correct. Yes. It's a little earlier if there was no trial. And it's a little longer if there was. So at the disposition hearing, that's sort of where the child's formally determined to be determined to be in foster care, if they're in licensed care, or formally determined to be in relative care. Often the child hasn't moved. Ideally, the child hasn't moved from day one, unless the child was in shelter, and the child's not supposed to be in shelter for more than 30 days. And so, at this point, we now have the case plan. Do we want to attempt showing the case plan, Vanessa?
Yeah.
Yeah? Okay. Have you guys seen a case plan?
Yes.
Some of you have. It's okay, you don't have to admit it or deny it. They're about, this is a small one, actually. It's about this thick. It's a small one. We had to use industrial sized staples. And this is single-sided. There's a lot, just go ahead and just camera it. A lot of boilerplate, a lot of just, legal language. Those lawyers. I have the language in there. In this particular case, it's a TPR adoption case plan. But services are, so the goal of this case is TPR. TPR is not a goal. So the goal of the case is adoption. And if you just kind of go to the task pages, eventually we'll get there. Even so, the parents are still, offered services. So this is a case, I haven't.
This is why you guys don't get these.
Yeah. They would kill us if we gave you these, I'm pretty sure. These are supposed to be prepared in a case plan conference. Usually, actually, I think it's the case managers who do it, and then it's reviewed for sufficiency by the lawyers. Again, it's supposed to be a process that helps develop, the services that relate to the facts of the case. But in this one, there's quite the kitchen sink in here. If you want to just stop on one of the pages, there. So, tasks and services for the mother. So one of the tasks for this mother is parenting skills classes. And look at all the things that she needs to complete in order to be considered completing this task. It's not just anymore about doing the service. Now it's about gaining from the service. It's about gaining insight into why your child was in care, and also remedying the circumstances that brought your child into care. Those are kind of the catch terms, but remedying the circumstances that brought your child into care. Okay. The question was, what if the parents are not English speaking? They do have case plans in Spanish and in Creole, in Haitian Creole.
What if their education is such that
they're not literate?
They're not literate.
Yes. Then their attorney should either literally go through it line by line, or an interpreter needs to go through it. Does that happen? I cannot say whether it does or not, but it's a very valid question. And so one of the questions we can ask of parents who come before us, right, is, do you understand what's in this case plan? Do you understand what you're supposed to do here? And if did someone, who explained this to you? How did you understand this? Now, the judges, during the disposition hearing, to loop back to the disposition hearing, and throw the slide back up, they're supposed to be making sure that the parents understand what's in the case plan. And they actually will take testimony from the parents. Do you understand this? This is the case, these are the tasks that you need to complete. They might not go through all the tasks on the record. Did someone explain this to you? But my experience with watching parents in court for many years is they're scared. It's scary for case managers. It's scary for a lot of people to go to court. It's scary for trained professional clinicians sometimes to go to court and testify or be in front of the judge. There's something about that black robe, and so parents might. Yes, I understand. Yes, 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 yes. It's all good. Whatever you tell me to do, I just want to get my kid back. And then, turn around to us and say, no clue. I have no clue.
So is the case worker supposed to sit down with them?
Ideally, it happens in that case planning conference where everyone sits down and they walk through it together, and there's a process that engages the parent in helping develop the case plan. Well, here are some of the services that we can offer to help you with parenting. Which one do you think would be the best one for you, which would be most convenient, which would you be able to accomplish. If we think there's 3 potential providers, we the case management agency, there's 3 potential providers that would be really good, the parent should be involved in making decisions so that the case plan is doable. And so I think that's another important thing for us to be looking at. Is this reasonable services aren't just the services. Is it reasonable for the parent to be able to get there? Is it reasonable for the parent? What are those barriers to successfully completing the case plan? And I think often the way case plan compliance is looked at, just to jump ahead a little bit, is it's looked at, well, they did it or they didn't. And I would like for us to be the sophisticated organization that we are and continue to ask, well, why? Why? What were the barriers? Why weren't you able to do this service? Not just yes or no, but why? And if they say, well, because I live north and the service is south, and I explained and I ride the bus, for anyone that's, you ride the bus, right? Riding the bus in Miami, is time consuming and challenging for many, and I would be lost completely, I can guarantee you. But even if you are a savvy bus rider, you're also required to have a job, right? That's usually part of the case plan. You're required to be working on getting a job or to have a job. How do you balance all of that if you have to go from the north part of the county to the south? The traffic alone, is a barrier. So I think we need to really be asking those questions. And sometimes there aren't good answers, and that's the way it is. The parents don't have a legitimate reason for not. And it helps either way, right? It helps if they say, look, I have requested repeatedly a service on the, near where I work in the north, and the agency says, well, no, you haven't, or this is the best we could do, then we make a recommendation and say, if this mom is going to successfully complete her case plan, she has to have a service that's closer to her house, and that's what's reasonable in this instant, and we, either the mom then has the opportunity to actually do a service, and she does it or not. But, I just think breaking down some of the barriers to permanency, that's one of the opportunities for us. It doesn't seem like a big thing, but it actually can have a big impact. The other thing is that the Guardian Ad Litem program is supposed to submit a predisposition report to the judge 72 hours prior to that disposition hearing, so that's something that we'll have access to. They have done some home visits, and you get that other perspective. We talked about the case plan, the services offered not just to the parents, but the children, and the foster parents, and the obligations of the department, of the case management agencies, and ultimately the state. This last paragraph I think is really important. It goes back to the adjudicatory order that we talked about. The services must be designed to improve the conditions of the home, aid in maintaining the child in the home if the child is still in the home, facilitate the child's safe return to the home, ensure proper care of the child, or facilitate the child's permanent placement. Not to fix every single thing that's wrong with the family, but it's about safety and well-being. I think we talked about most of these things. One other really important thing that has come up, and a question that's come up is, when you look at the case plans, it's like 10 or 5 even services that all have to be done today. You have to start today. And one of the things I'd like us to look at is, well, why don't we, it's like taking a new medicine, like titrate up a little bit. Why don't we start with like the biggest issue, which may be substance abuse? Because really, if you need parenting skills, but you're an active substance abuser, going to parenting skills classes is pretty worthless. One, you're setting yourself up for failure, and 2, it's a waste of resources. And so that's something else that I think we can add our lens to, saying, well, would it be possible in this case for a mom to just focus on substance abuse until for the next month and a half? And then can you refer her to a parenting class? And then can she start, or then can she then start, intensive clinical services? And then towards the end, when she's getting close to getting her child back, or when she's having overnight visits, then can we do parenting? Because parenting maybe wasn't really what she needed, the most. And if you see a case plan like that, call me, because I just want to read it. Because that's the sophisticated approach to helping these families. And yes, there's a lot of things that are needed to create safety and reduce risk, but we typically, as a system, start with everything. So let's talk about the judicial review. The judicial review, you guys know about the judicial review because this is what we do. But I want you to just have a little bit of the law. You all know that it's completely discretionary whether the judge sends us the case for review, right? So, underscoring that. Unfortunately. Although I really have to, we really do need to be grateful to the judges who have said, you know what, I'm going to start sending you everything at this shelter hearing. So at the time of shelter, we're going to set this case before the panel for 5 months from that day and have the judicial, you do the first judicial review. They're doing it, especially Judge Figueroa's division. I mean, we're seeing a lot of those cases. So we're going to get back up there eventually. It's required to happen every 6 months, but we hear it every 5 to make sure that if there's a reset or whatever, you guys know all that, right? The judges could do it every month if they wanted, or they could refer it to us. And so we've had some things lately where the judges have sent it down to us, like, we want you to hear this next week. I just did the review 2 months ago, but I wanted the panel to hear it now. This last bullet is a point of contention. And we are working behind the scenes on this issue. Written report of the guardian and the agency must be served on all parties, this is straight out of the statute, whose whereabouts are known to the foster parents or legal custodians and to the citizen review panel. How many hours? At least 72 hours. And in another time we'll talk about, and maybe in this month's newsletter we'll talk a little bit about this effort that we've shared with you before about trying to have the agencies start filing these things electronically, because there's electronic filing happening now, even in dependency court, and us having access to them a lot earlier, us being more able to prepare them, and you even having access to them electronically during the reviews. So we're trying to get there. You guys know that there's a 17.3 judicial review hearing. You can read about that. You guys are familiar with that, I'm sure. And the things that you do, the same things that the judges do, right? You determine compliance with the case plan. This is going to be a bigger issue now, Mike, to your question. This is going to be a much bigger part of our review hearings for these cases that come to us for that first judicial review. Because that's one of the main issues at that first judicial review, the 5-month review, is are the parents complying with the case plan? Are the case managers providing the services? Are the foster parents doing what they need to do? And it's all guided by what's listed in the case plan. So that's going to be in your...
Is the case plan going to be available to look at that 5 months?
What you're going to have is on your prep report, the case plan tasks will be listed in there, so you don't have to digest them.
Yeah, you do not want
To see that.
the dead tree. You want, the tasks, and that will be basically your checklist. Yeah, exactly. So at the judicial review, the other thing that we have to remember is if reunification isn't going well at that point, or the parents aren't engaged in services, we can also say, the goal needs to be reevaluated. We might not be in a position to say to what, but we can say the goal needs to be reevaluated. If it's reunification, but the parents, have fled town or whatever, or sometimes you'll see a parent get convicted and they're sentenced to 30 years. You'll see all sorts of things. We need to be mindful of. We can recommend that the goal be reevaluated. Okay, so where are we now? We passed a judicial review the 6 months after the child's removal. The initial judicial review, we're now every 6 months, so that's the judicial review we usually see, is that 10-month review, so you guys are familiar with that. A lot of water's under the bridge. Hopefully in these newer cases, by the time we see them at 10 months, they're going to be in a better situation than those cases that we haven't seen in 5 months. We're actually going to look at outcomes for each of those 2 groups and see whether our review process earlier has some sort of positive impact. And then we get down the line here, we're now 12 months after the child was placed in shelter. So 12 months after removal, the judge has to hold a judicial permanency review. This has to be held by the judge, or I believe the general magistrates can also hear these reviews. And that's what I like to refer to as the fish or cut bait hearing. At that point, if reunification has been the goal, if reunification is not imminent or likely to occur within a reasonable time period, a decision has to be made to change the goal. So if you look at the slide, permanency is the primary goal. The purpose of this hearing is to determine when the child will achieve the permanency goal, or whether modifying the goal is in the child's best interest. It's important also to note that a permanency hearing can be held at other times. And so what we will see a lot of, if cases have not been on track, I'm sure you've all experienced this. Well, the permanency hearing is next week, and the judicial review's before the panel today. Judge, can we just hear it all together?
Right, together.
Okay, so that's kind of what happens, which, from an judicial economy and efficiency perspective, that makes sense. I still think it's a different review when it comes to us. And a permanency review is required every 12 months that child's in care. So every 12 months, which we see unfortunately too many children in care for more than 1 or 2 12-month periods, right? You guys know, Mike, can you go to the next slide? You know your permanency options, right?
Right.
This is an order of preference. That's how the statute states it. Next slide, please. I want to just end with these 2 slides, unless I'm not allowed. Okay, reunification considerations. And the statute actually gives some guidance to the court about how to decide about reunification. And remember, that's not our decision to decide whether or not a child goes home. That's not our decision. Aren't you glad that the judges make that decision? But I wanted you and Mike and others to ask questions about, how do they make this decision? When we see some of these things going on, how do they make the decision? So the court bases its decision to reunify or to have increased visitation depending on how doing so will affect the safety, well-being, and physical and emotional health of the child. So what does that mean? They have to look at the compliance of the parents, the circumstances that caused the dependency, that caused that child to come into care, and whether those have been resolved, the stability and longevity of the child's placement, the preferences of the child, if the child's of sufficient age, the judge will ask the child, are you ready to go home? Do you think mom and dad are ready? These older kids, they know, you guys know these kids, they know what's going on. They're very savvy. Recommendations of the current custodian or caregiver and what the guardian thinks is appropriate. It's rare to see, in my personal experience, a judge return a child home when the guardian is not in favor of that. Unless the judge feels legally they have no other choice. The parent's done everything. Remember, reunification, I will just keep saying it, can occur any point in the case. We don't have to wait 12 months. Some parents are ready earlier. Some families are ready earlier, and that's something I think as a system, when we look at our statistics, our reunification within 12 months of removal statistics are very poor in comparison with the rest of the state.
Say that again?
So if reunification needs to happen within 12 months, our statistics as a community are very poor. Our reunifications don't typically happen within 12 months. Now many happen like between 12 and 18 months because of these little case plan extensions or getting some of the things sorted out. But that's an area where I think we can impact as well. There needs to be a written motion by the state. I'm almost done. The judge can decide I'm going to terminate jurisdiction, which means if that child comes back into care, if there's a new allegation of abuse, which happens sometimes, then that child, that's like a brand new case. If they retain jurisdiction, that child, it's almost like reopening the current case. So there's pros and cons. Most of the judges now are just saying, we're closing it, we're moving it out. The judge cannot terminate the supervision. You hear this TOS, termination of supervision. They can't terminate supervision until that child has been reunified and there has been in that home 6 months. So that is another thing to remember when we're talking about time and care. Sometimes these kids are home, but supervision isn't terminated until 6 months. The judge has to make sure everything is going well. Okay, am I done?